It is my deep honor and privilege to introduce today Sally Q. Yates, who was Deputy Attorney General from 2015 to 2017 in the Obama administration and Acting Attorney General in January 2017. This fall, Ms. Yates also served as Distinguished Lecturer in Government at Georgetown Law. As Deputy Attorney General, Ms. Yates oversaw the day-to-day operations of the Department of Justice's law enforcement agencies, prosecutorial, litigation, and national security components, Federal Bureau of Prisons, and grant-making and legal services offices. Ms. Yates also introduced two new policies: the Clemency Initiative, which commuted the sentences of nonviolent drug offenders, and the Yates Memo, which prioritized individual accountability for corporate crimes. Ms. Yates served in the Department of Justice for over 27 years. After practicing commercial litigation in her native Atlanta, she entered public service in 1989 as an assistant U.S. attorney in the Atlanta office, prosecuting white-collar crimes and public corruption cases, as well as serving as the lead prosecutor of Olympic bomber Eric Rudolph. In 2010, she was appointed by President Obama as the first female U.S. attorney of the Northern District of Georgia. She also holds a BA in journalism and a JD from the University of Georgia. She and her husband have 2 children. Please join me in welcoming Ms. Yates, who will now discuss using essential norms to preserve the rule of law.
Good morning, everyone. It is my deep honor to introduce you to Professor Larry Rosenwald, who will be giving the introductory keynote address to the Albright cohort of 2018. Professor Rosenwald is the Ann Pierce Rogers Professor of English at Wellesley College, as well as the director of the Peace and Justice Studies program over here. He has completed his undergraduate education, as well as his master's and his PhD at Columbia University between 1970 and 1979. Professor Rosenwald has written about a multitude of topics, including literary multilingualism, which is the mix of 2 or more languages in the same text. He has also published translations of texts written in German, French, Yiddish, Latin, and Italian. He is a pacifist, a war tax resister, and has been a member of the New England War Tax Resistance since 1987. A recent work of his in this area is War No More, an anthology published in 2016 by the Library of America. It contains the perspectives of 150 writers advocating for peace. Please welcome me in welcoming Professor Rosenwald as he gives the introductory keynote address to the Albright cohort of 2018. Thank you.
Just to be clear about the format, this is an interview or a conversation. I'll ask some questions. Sally will respond to them. And then at a certain point, I'll turn the questioning over to you, because I imagine that you also have questions you'd like to ask. I'll get to my first question after a prefatory remark. Your commitment to justice and to law are an inspiration, and you do us honor by being here. It's in that context that I'll ask all of my questions, even the most probing ones.
Well, we didn't say anything about probing questions now.
The first question is an orienting question. The fellows have read work by you and about you, but it might still be interesting for them to hear you tell the story of the events and choices that led to being removed from your job as acting Attorney General. In what I've read, you tell that story in a beautifully precise and unpretentious way, and I thought it might be good for us to have that story in common as we begin the conversation.
I think we're going to go straight to me being fired, apparently. No, but first let me thank all of you all for the privilege of being here with you today. It's terrific to be here at Wellesley as part of the Albright Institute, here with Professor Rosenwald, and then all of you, the future women leaders of our country. So is it always this cold here, though? I do have to ask you that. I'm coming from Atlanta, so the schools in Atlanta, I learned this morning, were shut down just because there was a prediction of some freezing rain today. Not even any snow or ice, just the prediction of it. So you guys are much hardier here than we are back in Atlanta. But I am delighted to be here. And the story there gets a little bit of background in terms of how I came to be fired. It's a tradition at the Department of Justice when there's a change in administrations for the Deputy Attorney General, the number 2 in the Justice Department, to serve as the acting Attorney General until the new AG is confirmed. And that's really important that we have continuity in all parts of the government, but particularly important at DOJ, where you have really essential law enforcement and national security issues to attend to there. And as you heard, I've been part of DOJ for almost 30 years, and so I was happy to stay on during that time that we were awaiting Senator Sessions' confirmation as Attorney General. But there's another tradition during that time as well, and that is that usually during the time when a holdover is there as the acting Attorney General, it's an uneventful time. There's sort of an understanding that nothing really changes during that time. The policies of the Obama administration that were in place will stay the same. Our positions on cases stay the same. Likewise, I wouldn't really haul off and issue any new policies or directives, but that things just stay kind of status quo during that time. So imagine my surprise on Friday, late the afternoon it was Friday, January 27th, and I was on my way back to Atlanta for an awards dinner that my husband was getting an award from an organization there, and it was like 5 or 5:30 or so, and my principal deputy, I was able to keep one of my assistants with me during this time. He called and said, after you left, I went online, it's kind of like the cat's away, so then he starts, sort of catching up on news and sees that on the New York Times website that the president has issued some kind of executive order barring immigration from 6 Muslim predominant countries. And this was the first that we had heard of. Not a peep from the White House before this. Despite the fact that with this executive order in place, DOJ had to have lawyers in court the very next morning, Saturday morning, addressing individuals who were coming into the country and were filing challenges. And so we spent the majority of the weekend trying to get our arms around what was intended in this executive order. What was the president trying to accomplish? What were the parameters? Who was included? Who was not included? And then on Monday, I had issued a directive at that point that our lawyers could defend on procedural grounds, meaning that if someone was admitted, and so the case is mooted out, they could defend on procedural grounds, but that we weren't going to take a position on the constitutionality of the executive order until we had an opportunity to determine whether we believed it was constitutional. And so Monday morning, then I convened a meeting of all the folks at DOJ, which included both, and I'm sorry, I won't be this long-winded with all the questions, but all the Trump administration lawyers that were then in place and were at DOJ, as well as the career lawyers as well. And we talked through what the various challenges were to the executive order. I'd read the briefs and the cases, and I was not convinced at the end of that discussion that the executive order was lawful or constitutional. And I can't really disclose the discussions that went on there because that's a privileged communication within DOJ. But I wasn't convinced that it was lawful or constitutional. And I was particularly troubled that to defend the executive order was going to require us to argue that the EO had absolutely nothing to do with religion, that it was all based on national security and absolutely nothing to do with religion, which given the president's statements both on the campaign trail and after his election, simply did not ring true. And it put the Department of Justice in the position of having to advance a defense that was not grounded in truth. And given my belief that it wasn't lawful or constitutional, that our defense would require us to argue something that wasn't true, I knew that this was not something that I could be a part of. And so then sort of the more difficult question was, do you stay or do you go? Do you resign, or do you direct the department not to defend the EO? And I understand that there are people out there, and everybody is certainly entitled to their opinion. There are people of goodwill who believe that the appropriate course for me at that point was to resign. But here's the thing, is that I felt like, and I've said before, that that would have protected my individual integrity, my personal integrity, but it would not have protected the integrity of the Department of Justice. And I remembered back at my confirmation hearing when there were a number of senators, including now Attorney General Sessions, who were quite insistent in asking me, if the president asks you to do something that's unlawful or unconstitutional, and Senator Sessions even said, or just that would bring disrespect to the Department of Justice, will you say no? They didn't ask me, will you resign? They said, will you say no? And I ultimately concluded that resigning wouldn't be doing my job. And I was in the chair, I was the acting attorney general, and I needed to do my job, and so that's what I did.
Thank you, and I am grateful for the richness of the description you gave. I like thick textured accounts.
Is that long-winded? Is that just a nice way of saying?
No, that's a way of admiring and attention to detail. And I think that thinking about the questions of policy that you all are focusing on means focusing on questions of detail, or it's vague and imprecise and impractical. You used a phrase when you were speaking just now, the phrase grounded in truth. You didn't feel you could defend an order that was not grounded in truth. You've said that, you said that in your congressional testimony also, and I was very struck by that phrase, as you know, partly because Gandhi calls his autobiography experiments in truth. Truth is a resonant word, and not always, at least in my admittedly secondhand experience, lawyer's favorite word. Could you say a bit about truth, grounded in truth, why that's the phrase that beautifully resonant phrase that you come back to and center on?
Well, first, obviously, I am no Gandhi. You know, the Department of Justice is different, has a different responsibility than any other law firm in the country. Yes, DOJ represents clients in the sense that we represent the executive and agencies in litigation in the courts, but the responsibility of DOJ is broader and higher than just representing a client. You know, the Department of Justice really defines for the citizens of this country our justice system. And, you know, arguing something just because maybe we could get away with it, or maybe even if you were a private litigant, you could sort of put aside the issue there that I identified, although still don't think you should, but DOJ, again, is different. Mm-hmm. You know, I still say we. I have to get, after 27 years, it's hard not to say we when I refer to DOJ. But, you know, the Department of Justice has an obligation not just to win cases, not to put people in prison who violate the law, but to seek justice. And that has to always mean, under every circumstance, speaking truth. And that was one of the real stumbling blocks for me in defending this executive order. And when you combined that with the fact that this was an order that was about a fundamental issue of religious liberty and whether we were going to be discriminating against Muslim majority countries, I mean, you combine those two things, That's just not what DOJ is about, in my view.
Thank you. That's very moving, and it also leads me to a kind of follow-up question, which is maybe as close as I'm going to come to a probing question in the course of this conversation.
Those will come from you guys,
You,
right?
you've spoken about the difference between the law as it is and the law as it should be. It's an important distinction. And for me, for people my age, distinguishing between the law as it is and the law as it should be evokes memories and thoughts about people who've disobeyed what they regarded as unjust laws for reasons of conscience. Civil rights activists, Daniel Ellsberg, the person who released the Pentagon Papers, who's now in the news because he just published a memoir, Chelsea Manning, Edward Snowden. I'm not asking you to weigh in on the merits of individual cases of civil disobedience, but I would be interested in hearing what you think of civil disobedience more generally and the question of what one is supposed to do both as citizen and as lawyer in confronting a law that one judges to be of its nature unjust.
Well, certainly there have been important moments of civil disobedience across the course of our history. You know, you can go back to the Tea Party, may have been sort of the first act of civil disobedience. And certainly, you know, looking to the civil rights movement when Rosa Parks refused to give up her seat, or you had sit-ins at lunch counters, or the Freedom Riders. I mean, all of those were really pivotal moments in our country's history and holding us to our core values. But I'll say I didn't view and don't believe that my act was in any way an act of civil disobedience. In fact, I think it was the opposite of that. I believed that I was protecting adherence to the law and the Constitution rather than disobeying it. But I recognize that there can be circumstances. I mean, in those times, you know, people have made decisions that they were going to disobey the law, but also that they were going to accept the consequences of that. Mm-hmm. And as a result of that, to make a statement about what they believe the law should be. And, you know, the law is not supposed to be just, a set of do's and don'ts and rules. It's supposed to be a reflection of our values. And our values come from the people. You heard in the introduction that I've been at Georgetown Law School right now. And, you know, the motto of that law school is, law is but the means, justice is the end. And I think we have to keep that in mind always. But, you know, generally, I'm a prosecutor. I believe in complying with the law and enforcing the law. And so, you know, I would encourage when there are laws that we believe to be unjust, that we work to try to change those laws. And that means speaking out about injustice. It means, you know, perhaps calling your congressmen or senators, you know, every day if you need to. There are ways, oftentimes, within the system to be able to address those injustices.
Just a follow-up question. I admire very much what you've been able to do within the system, and it's important for me as a person situated often outside the system to acknowledge the justice seeking that can take place within it. Is it your sense, though, that sometimes the legal remedies available to us, if the law is sufficiently unjust and the situation is sufficiently pressing, might not suffice? I mean, the people who disobeyed unjust laws in the civil rights movement were also protesting against them and registering people to vote for candidates who opposed them. They were doing all of the things connected with legal remedies, but they regarded those as insufficient. Is it your sense that sometimes they are insufficient?
Well, I think certainly our country's history has reflected points, and the civil rights movement would be, I think, the primary example, where it required the all tools approach, you might say, to bring about the change that was needed in our country. I think that we've come a long way since then, in terms of, for example, whistleblower laws and inspectors general that exist within each federal agency, for example, that provide protection for individuals to be able to go and to be able to provide information that would reveal government misconduct or wrongdoing. And so certainly I acknowledge that over the course of our country's history, there have been times where civil disobedience has been an important turning point for us. There may very well be instances again, but as I said, I'm a rules girl. And so I generally think that the best way is to be able to approach it from within the law to try to change the law.
Yes, I think what one might say about what you did, this one act that everybody's focusing on, is that it's a principled act of civil obedience, that you were obeying the law as you understood it, and that is a very great power, I think, that kind of action. I noticed when you speak, and I noticed looking at you in the videos that I'd seen, that you take great pleasure in linking yourself to the long historical patterns of this country, to finding sources in tradition, and also in saying that it's American values that are leading you to challenge American institutions. That's a long tradition of its own, of rebels or disobeyers or obeyers who've articulated who've based their views on a sense of what the true American values are. That makes you a patriot, right, in some important way? And I say that with a lot of admiration, and I wonder, do you think of yourself as being a patriot? Do you think patriotism is a useful value these days? It feels like it is in you. Is that true?
I don't know if I would call myself, I believe I am unabashedly and unapologetically patriotic. No question about that. Yeah. I love this country. I love the principles and the values on which our country was founded. We haven't always lived up to them. We are clearly a work in progress in this country toward that more perfect union, but I think the values that bind us together, regardless of where we are on the political spectrum, are good and noble values, and I think that it's up to all of us to continue to push our country to live up to those promises. I see that, protecting someone's right, for example, of free speech, to say something that I might disagree with. I don't think there's anything more patriotic than what you can do there. And I think, in this time that we're in right now, where it seems that we get farther and farther pushed to our corners, that the way we get through all of this is by remembering those values and principles and institutions like an independent Department of Justice and courts, a free press, those institutions that, putting aside where we might be on various policy issues, those institutions that are really essential to protecting our democracy.
Thank you. It's very bracing for me, I'll just say, to have that uncompromised love of country put to such good use. I say that because I come, as a college student of the 60s, I grew up in an anti-patriotic moment. I think the first thing I learned about patriotism was Samuel Johnson's remark that it was the last refuge of a scoundrel. And it's only lately, I think, that I've come to see the energies of that patriotic feeling, the way in which it can animate, defense of the vulnerable, for example, as you suggest. So it's very moving.
Perhaps that's false patriotism, though, where patriotism is used to try to squelch dissent.
Sure.
That, to me, is not true patriotism.
I agree. And I think Johnson actually meant that. I think he meant it's the cloak you put on to disguise the behavior you wish to carry out for selfish reasons, right? Rather than the thing that animates the action. Whereas in your case, I think it's the thing that animates the action, and I'm moved by that. I really am. I'm going to move to some different territories of questioning. I'm going to come back to the question of institutions because I know how central that is for you. But one territory that I need to explore a little, this being Wellesley College, distinguished women's college, is the question of gender. I think it's that for anyone who's either a student at Wellesley or a longtime faculty or a short-time faculty member at Wellesley, a staff person at Wellesley, it's inevitable that such people looking at your Senate testimony, for example, for which a heartfelt bravo because you were so patient, resilient, clear, and courteous, it's inevitable to notice that it's a lot of men grilling a woman. And
Otherwise known as mansplaining? Is that what
yes,
you're
well,
okay.
it felt like that, yeah, that's what they're doing, but there are also so many of them. And I wondered, I haven't seen comments of yours about this, maybe you've made them. I wonder, is there a gendered aspect to what happened to you across the span of your career, surely, but also in relation to this very charged incident in it? Do you think of it as gendered in some way?
Well, certainly over the course of my career, I started in a law enforcement arena as a prosecutor back in 1989. There weren't a whole lot of female prosecutors in the U.S. Attorney's Office at that point. And certainly most of law enforcement, FBI, and the agencies with whom you work, that's a pretty male-dominated arena. And so over the course of my time there, I've sort of gotten used to being, if not the only woman in the room, one of the few women in the room. And I'm not saying that makes it okay, because it's not. But sort of to go the full spectrum, there was also a point when I was Deputy Attorney General, when I was in Attorney General Lynch's conference room in a meeting with her, and the table was full. It's a huge table, and all the chairs were filled along, the outside of the room. And when we were getting up, my principal deputy, who was a man, looked at me and said, "Did you realize I was the only man in the room during this meeting?" To which I looked and I said, "Actually, I didn't even notice that." And so maybe it's a good thing that we've come so far that he was the only man in the room. And secondly, that at that particular moment, that didn't even register. In the Senate testimony, I'll confess, I've had other people sort of make that observation to me. At that moment, during that time, I was so focused on the questions that were being asked of me and trying to listen to those questions and to be able to give real answers to those before I was cut off, that I was kind of oblivious to what was going on in the room around me. And certainly I was aware that most of them sitting in the chairs up there were men, but that just wasn't something at that particular moment that was all that relevant to me. It was more trying to listen to the questions and to give them a substantive answer back, and to try to avoid this devolving into political theater, which is not what a congressional hearing, in my view, ought to be. So certainly, look, the legal field, and particularly the law enforcement legal field, is one that has been heavily male-dominated for a lot of years. But things are changing. They're changing in a whole lot of different ways for women right now, and I think that's one area where it's changing as well, and high time.
That's very well said. I'm going to ask a follow-up question. Imagining that in this room are people who might like to pursue a career like the career you've created for yourself, and who might like some advice about how to do that. Do you have counsel to offer other than, nevertheless, she persisted?
I probably should have come up with some really great, insightful, pithy advice, since I should expect that I would be asked to give you that here today. I guess what I've sort of come to over both the course of my career and over the last year, where I've been traveling around and doing a good bit of speaking at different colleges and universities and law schools, and particularly with women, is that, we're at a point now where I think the most powerful woman you can be is your authentic self. When I was coming along, I remember there was sort of a fear or hesitation among professional women to be considered too aggressive, that you felt like you had to kind of take the edge off a little bit, because if you were too assertive, you would alienate not just the men in the room, but you might alienate the other women in the room. And so you had to be very conscious of those things. I can remember trials where I was very conscious of not coming across as too aggressive. I think those days are over. I think that you should feel comfortable with who you are in your own skin and able to be, again, your authentic self. But that also means you don't have to push yourself into a persona that also isn't you. I mean, if we're truly going to grab hold to the equality that every woman in this world deserves, it means she doesn't have to act like a man. You get to, and that I believe is also what's going to make you the most effective person. I strongly believe that people are at their most persuasive, their most effective when they're authentic, when they are themselves, because we can all see through immediately when someone is trying to take on, whether it's just a personality persona or an argument they don't really believe in, and they lose all credibility. So if we're going to grab hold of this moment, like I think we all really should, and make it more than a moment but a turning point, I think we should all feel empowered to be who we really are, and to feel that that's better than okay, that that's powerful.
That's wonderful, and I'm glad that this is being recorded, because if you need to have a response available when somebody asks you the question the next time,
Can I go with that?
I would say you could go with that. That's remarkable. The second sort of outside the mainline territory that I'd like to ask you a question about is technology, which, as the Albright Fellows know, is the center or at the center of this particular iteration of the Institute. It's not a question I myself usually ask very well, but I've learned to ask it partly from conversations with Takis Metaxas, who points out the ways in which technological matters bear on ethical or political questions that I'm occupied with. So I'll ask you a similar question and invite you to improvise. So the Institute, as noted, is focusing on harnessing the power of technology for the betterment of society, which is great, but we can't not notice that one major impact of technology in our society at the moment is how it's reducing our privacy and our control over privacy. One, that's partly a legal matter, and one sub-question within the question about technology is how should we respond to the challenges posed by the diminution of our privacy? How much in the end does privacy matter? I say that because most of the defenses of privacy I'm familiar with don't seem to me very robust. So any part of that question or the whole of the question as you feel inclined to respond.
Well, I'll try to address that, and then actually in the Q&A, I would love to hear from you all on this point as well. I think in terms of technology and privacy, it seems we all have to recognize that with every Google search or Facebook post or tweet that we post, we are giving up a bit of our privacy. We are putting information about ourselves out into the world, and we may be doing it for one purpose, but then it can be used by others for a different purpose. Now, technology, though, obviously has tremendous advantages. I mean, we can communicate with thousands, if not millions of people literally in a matter of seconds. We can get news from alternative sources that we might not have had before. We can register our views very quickly and have a forum that oftentimes other than people who were in leadership positions could do. But those are conscious decisions that we're making when you put that information out there. I think that we all have to recognize that we are making a decision to give up some of our privacy, and that with that technology also comes risk.